We're live.
Welcome to the second meeting of the House Work Group on Judicial Transparency. It is January 12th at 1 o'clock. This is a virtual work group meeting, so please be patient if we encounter any technical or streaming issues. Before we begin, I remind work group members that this briefing is being streamed on the Maryland General Assembly's YouTube channel. Work group members will be muted throughout the briefing. If they have questions, they will use the raise your hand function within your Zoom window. I'll recognize you to ask a question, and just give us a moment while Dylan unmutes your screen. During our first meeting, we were joined by Dr. David Soule, who provided an overview on criminal sentencing policy and procedures that exist in Maryland, and we appreciated his remarks. Today, we're joined by two panels. The first, a group of legal experts and a former retired judge. And then we will hear from two judges from the Maryland judiciary to provide their feedback and perspective on the issue of judicial transparency. For our first panel, we'll hear from Judge Andre Davis, who previously served as the city solicitor in Baltimore and the senior judge on the U.S. Court of Appeals for the Fourth Circuit. We'll then hear from Ron Weish, the Dean of the University of Baltimore Law School. After these panelists, we'll have some questions for them. And then for our second panel, we'll hear from the Maryland Judiciary. We're joined today by the District Court's Chief Judge, Judge Morrissey, and Judge Shannon Avery from the Baltimore City, I believe it is Circuit Court, correct? From the Circuit Court. After these panelists conclude their remarks, I'll open the floor to questions for them. So with that, we're going to hear first in our first group from Judge Davis, who I would like to thank for being here with us today, and I'll ask you to get underway. Judge Davis.
Thank you very much, Chairman Clippinger, and Happy New Year to all of you, and my best wishes to the delegates for a fruitful and productive session. I really appreciate the chairman's invitation to me to offer some observations to the work group. It's very important work that you've undertaken. Few things are more important than transparency in government, and after all, courts are part of government. But to talk about judicial transparency requires, I think, first, that consideration be given and some discussion be had about some of the underlying foundational principles which support the idea of transparency in the courts. This is not a limited list. This is not an exhaustive list, but the three things that come immediately to mind, I think, are number one, separation of powers, number two, judicial independence, and number three, the rule of law. Just last week, Chief Justice Roberts, in his annual report to the people and to Congress as the Chief Justice of the United States, once again, as his predecessors have done, and indeed as he has done, has cautioned about the importance of separation of powers in the operation of our constitutional government. And this is true, of course, at both the state and federal level. Now, to invoke separation of powers is not remotely to suggest, of course, that the executive and legislative branches of government have no role to play and indeed have no significant influence over the operation of the courts. Clearly, they do, and they should. Not least among them, of course, are matters of budget. But at the same time, I think we all recognize that the separation of powers principle embedded in our constitutions really is a key component of our constitutional system. And that needs to be kept in mind as we approach the subject of judicial transparency. Judicial independence, of course, is a second feature. Again, this is not an exhaustive list, but it's absolutely critical that part and parcel of separation of powers is judicial independence. All of us want courts and judges who will decide the disputes that are brought before the courts fairly and impartially, on the basis of the judges or the jury's best efforts to determine the facts and the judge's good faith application of legal principles to those facts. Bearing in mind at all times that what we're after are fair outcomes to both the winner and the loser in a case, but also a demonstrated commitment to equal justice under law, which is also one of those imperatives of our system. And then finally, overriding all of that, of course, in a sense, overriding it, is the imperative of the rule of law. And it is the rule of law that really guides all of what judges and judiciaries do, and frankly, what legislators and executive branch officials do. The rule of law, no person is above the law. Every person is entitled to equal treatment under the law. And decision-making by the courts must be rooted in developed, recognizable, often settled principles of law that drive the outcome of cases. So all of that is by way of background to say that while transparency in the judiciary is critically important, it must be tempered. A desire for transparency must be tempered, if you will, by recognition of these underlying and sometimes competing principles. Now, my own personal involvement in these issues goes back quite a ways. Back in the early 90s, I, along with my then colleague, Marvin Steinberg, some of you may be old enough to remember Judge Steinberg, a member of the the Circuit Court for Baltimore City. He and I were sort of a team of two that were working together with members of the American Bar Association to stand up a form of judicial evaluation program here in Maryland. It was a failed effort. It's a very controversial subject, but some jurisdictions around the country have actually been successful in creating, again, what I refer to as a judicial performance evaluation system or metric, whereby judges can be evaluated in fair ways that don't run afoul of some of the principles that I've mentioned, and in systems in which the goal of the evaluation process is to help judges be better judges. Again, in my 30 plus years as a judge, or more than 40 years as a lawyer, I have never, ever met a judge or heard of a judge who, one, wanted to be average, and two, wanted to be unaccountable. Judges welcome accountability assessments when they are done appropriately, with due regard for the underlying principles that inform the judge's work. Now, I have to confess that even before my involvement with Judge Steinberg, the failed involvement in trying to set up evaluation systems, I was one of few judges in Maryland who, and I remain one who is opposed to the election of judges, at least the contested election of judges. Again, that's a very controversial subject. There's a lot of data out there, not so much in Maryland, but around the country, that demonstrate that one of the things that skews judicial performance, unfortunately, is the electoral process. And I know that in this country, we have a deep commitment to the electoral process, but there are 38 or 39 states that use the electoral process, some of them straight up partisan elections, which we don't have in Maryland, fortunately. And in fact, if you're going to elect judges, in my view, then the way to do that is the way Maryland does it, by giving a long term for the judges of general jurisdiction courts, such as our circuit courts, and making the appellate selection of judges merit-based and nonpartisan, non-contested. In other words, up or down, yes or no, on every judge on our appellate courts every 10 years. That's a sensible way to go about evaluating judges. I'll close by just observing that what's important, really, I think, very important in light of the principles I've laid out, is that judges be in control of whatever evaluation transparency measure is put in place. Which is not to say that there isn't a place for public involvement and public input. And we have ready examples of this practice right here in Maryland, of course. On our judicial nominating commissions, trial and appellate, as you all know, I'm sure, we have lay people, members of those commissions. I just happened to have a conversation with one just the other night who called me because I'm a reference for one of the candidates for an opening in Maryland right now. And we had a wonderful 30-minute conversation. And I thanked her repeatedly. She's a non-lawyer, a member of the public who serves under our regime of judicial nominating commissions on the commissions. And they're so critically important to that process. Similarly, Maryland has made great success, I think, in standing up. I'm sure Judge Avery and Judge Morrissey will know exactly, but about 15 years or so ago, maybe as much as 20, Maryland created the judicial disciplinary process that now works, I think, very well from what I've seen. The investigative personnel that work for the commission are very aggressive, as they should be, in looking into missteps and misconduct by judges. And there are non-lawyer, non-judge members of that body that inform the work of the body. But ultimately, of course, judges have to be responsible for disciplining and regulating their own processes. So finally, let me just say, we all know that, tough on crime is a shibboleth that goes way, way, way back. And it helps to get some people in some jurisdictions elected or reelected or more votes. But the truth is, there are no pro-crime judges anywhere in this state. It just doesn't exist. The idea that judges somehow, either intentionally or negligently, fall down on the job when it comes to doing their part in keeping the community safe, with all respect, is just absurd. Judges live in the communities where the criminal acts take place. And if I can share a very quick, personal story, when my wife got mugged across the street from the Belvedere Hotel some years ago in broad daylight, the guy who did that didn't care she was the wife of a judge, didn't care who she was. My dear friend, a judge I won't name, encountered a terrible criminal incident not too long ago in one of the quote unquote nicer areas of Baltimore City. It happens to all of us. We're all potential victims, and not just potential victims, but real victims. So the problems of crime are multifaceted. They call for approaches to solve those problems from every part of the government, private sector. We need to get at root causes. And yes, we need to improve the response of state government to criminal activity. But the way to do it is not to blame the judges. It's not the fault of the judges, and it's not the fault of the prosecutors. We all have a role to play in addressing the problem of crime, and focusing narrowly, in my view, on criminal sentencing by judges is just the worst approach to judicial transparency that one could actually enact into state law or any law. I appreciate, again, the opportunity. I look forward to any and all questions that I might be able to help in your work. And I look forward to hearing from Judge Morrissey and Judge Avery, as well as my good friend, Dean Weiss, on what their perspectives are And I hope that I've been helpful in some way. Thank you very much, Mr. Chair.
Great. Thank you very much, Judge. We'll go now to Dean Ronald Weish from the University of Baltimore School of Law. Dean Weish.
Thank you very much. I appreciate the chairman for inviting me to be with you today, and I welcome the opportunity to speak on this important subject. Great privilege for me to share a panel with the legendary Judge Davis, as well as Judges Morrissey and Avery, both of whom graduates of the University of Baltimore School of Law. We're so proud of them. I want to say that my perspective on this issue is twofold. First of all, as the dean of one of the two law schools in the state of Maryland, I care deeply about the rule of law and judicial independence, themes that Judge Davis very eloquently spoke of. And I feel it's my duty to fight to preserve the respect that the Maryland judiciary very much deserves. I've been very impressed. I'm not a Marylander by birth. I came here to become dean at UB. And I've been enormously impressed in my 9 years as dean with the quality of the judiciary and the earnestness and hard work that judges in our state bring to their difficult and sensitive work. And I feel it's my job as a law school dean to help preserve the independence of the judiciary. The second perspective I bring is from my own career. I was a prosecutor at 2 points in my career. I began after law school as an assistant district attorney in the office of the Manhattan District Attorney in New York. And more recently, just before coming up to UB, I was an assistant attorney general in the United States Department of Justice. And in between, I had a good deal of involvement with the federal sentencing guideline system. I worked as special counsel to the U.S. Sentencing Commission, and then worked on legislative issues related to federal sentencing for both Senator Edward M. Kennedy and the recently deceased Senator Harry Reid. I came to understand the federal sentencing guideline system, which has changed dramatically in recent years. It was enacted in the 1980s as a very rigid mathematical attempt to cabin judicial discretion, and was accompanied more or less at the same time by a set of mandatory minimum sentencing laws in which judges had no discretion. And the kind of double whammy of the mandatory minimum sentencing laws and the very mandatory rigid sentencing guidelines proved to be unworkable. Many of the mandatory minimums are still in place, but the guideline system has evolved in part because there was such pressure to tie the judge's hands. And eventually, the Supreme Court found the system to be unconstitutional and a violation of the Sixth Amendment. And the guidelines, the federal sentencing guidelines, are now advisory in the way that the Maryland sentencing guidelines are. And that has proved to be a much more effective, sensible system, because while it's appropriate to eliminate unwarranted disparity, no two criminal cases are alike. No two crimes are alike, and no two criminal defendants are alike. And it's a fool's errand to try and put them into rigid boxes. So as I look at the proposal that you all have considered in recent years and will be considering again this year, I see two aspects. First of all, there's a proposal to require certain crimes to be within the sentencing guidelines. Now, as I understand it, there's a very high rate of compliance with the guidelines currently. So this may be a solution in search of a problem. That is to say, judges are not sort of wildly departing from the guidelines, but it's a mistake to force them as a matter of law to sentence within rigid boxes. There should always be an opportunity for judges to exercise discretion and to do justice in individual cases. So I very strongly oppose any effort to make the Maryland sentencing guidelines mandatory in the way that the federal sentencing guidelines used to be. And as I say, that proved to be unworkable at the federal level. And I think it would be a mistake to move Maryland in that direction. The Maryland sentencing guidelines in their current advisory form work well. And the second aspect of the proposal is the issue of transparency, and this proposal to require that information be disseminated about the sentencing practices of individual judges. Now, as Judge Davis said, judges are accountable. Each sentence is a public act and a public fact, and no one is trying to hide it. But the kind of information and the form in which this proposal would have the information disseminated is likely to be highly misleading. Because, as I said, no two sentences, no two crimes are the same, and no two criminals, no two defendants are the same. And a cold presentation of the sentence as against the charge of which the defendant was convicted doesn't begin to tell you all the nuances and sensitivity and complexity of the individual decision. And attempting to aggregate those facts for individual judges would not only be misleading, but I fear that it would have the effect of intimidating and pressuring judges in a way that is entirely inappropriate. I agree with Judge Davis that any effort to disseminate information about sentencing should be in the hands of the judiciary. The judges know best what this information means and how to present it. Among other things, they understand the influence of plea bargaining on the process and on the sentence. Many sentences are the product of prosecutorial decisions, not judicial decisions, or at least prosecutorial influence over the decision through the plea bargaining process. And again, a cold, bare presentation of a sentence and the charge of which the defendant was convicted doesn't begin to tell you that story, doesn't begin to tell you that nuance. So for these reasons, I think the proposal is unwise in its current form, and I would leave it to the judiciary to decide how best to respond to reasonable calls for more transparency. I understand what the impetus for this proposal is, and there may be merit in getting more information out there, but I would trust Judge Morrissey, Judge Avery, and the rest of the Maryland judiciary to find the right way to respond to that call. And this proposal is not the right way. We need to be sure that the General Assembly doesn't take steps that unduly pressures or intimidates judges. That's not the way you want to go, I respectfully suggest. Thank you very much. I'm also glad to answer questions.
Okay. Are there questions for this first panel from members of the work group? No one is asking any questions, so I'm going to ask a couple questions and then we'll see if that sparks anything. Judge Davis, you talked about a judicial performance evaluation metric, and you talked about your work on this from some time ago. What was part of that metric? What are the things that judges in that metric would be measuring and then providing to the public? What were some of the things?
That's a great question, Mr. Chairman. And the easy, quick, and correct answer is a focus, among other things, on work efficiency. Historically, and indeed, when I became a judge in Maryland in 1987, one of the challenges facing the courts in Maryland, particularly in Baltimore City, was just an incredible backlog of cases. And that was the product, in part, of judges taking a casual approach to their responsibilities, but also had to do a lot with just overloaded courts. And it also had to do with inefficiencies in the court, a lack of technology and a lack of systems. So that one of the things the federal courts did after a study around the same time was the institution of what came to be called the 6-month list. And this is very notable in the federal judiciary. So what happened in the early 90s, after the federal courts studied the issue of efficiency, is that every federal judge was required to publicize the matters that had been pending before them for more than 6 months. Now, understand, in the federal system, unlike most of the jurisdictions in Maryland, we have an individual assignment system. And so when a case is filed, when a matter goes into court, it is assigned to that judge and only that judge. And the judge is responsible for the progress of that case, whether it's a civil case or a criminal case. And of course, in a criminal case, you have the Speedy Trial Act, which serves to make sure that the judge's process the work promptly. So my answer in part to your question is the kinds of things that I think legislators, members of the executive branch, and people at large want to know about. Is the judge doing the work in a timely fashion so that the taxpayers' funds are being expended in a reasonable and appropriate way? So those are the kinds of things that could go into an evaluation system. Another thing that happens, just to give an example, a number of jurisdictions around the state of Maryland and around the country have so-called anonymous evaluation programs where lawyers get to submit comments to judges about the judge's demeanor. Is the judge respectful of lawyers and litigants? Does the judge start court on time and is in that manner respectful of the time that others have? Do the judges get their decisions, their written decisions and orders out on time? So the focus primarily is on efficiency and getting the work out. And within a system, you can have what sometimes is called a buddy system, where a judge is paired with another judge and there's sort of mutual mentoring going on, and feedback loops are created for judges, because judges want to be excellent. Judges want to be excellent in every respect. And so the systems that I have in mind and that the ABA was trying to put in place and has put in place around the country are designed to give judges the tools to be better at what they do, to offer constructive criticism, but not to, as the dean mentioned, not to create all kinds of misperceptions and misunderstandings by highlighting what a judge does in a particular case as compared to what some abstract measure of performance should be. Every case is different. So we want to take a holistic approach to the evaluation of judges, aimed at having judges improve their performance as judges.
Okay. Are there questions from the work group? Let's see. Wasn't sure if I saw Delegate Davis going to her button, but no. Oh, I do. Okay, that's fine. Delegate Davis, please.
You know me too well, Mr. Chair. I have a question. Last meeting, we heard from the Maryland Sentencing Commission. I'm not sure if I have.
That's right. We heard from the Sentencing Commission. Yes.
We heard from the Sentencing Commission. And one of the things that they brought up was that one of the findings, I mean, there were several findings that kind of gave me pause, but one of them that I'd like to discuss with this panel is they found that citizens who execute or elect their right to a trial by jury end up with stiffer sentences. I mean, is that okay with the judiciary? And is there a way for the judiciary to police itself and to address this? Because citizens are concerned.
I could take a crack at that, Mr. Chair. So
that's fine. I saw Judge Davis speaking too, but we'll go with you, Dean.
I was inviting the dean to take first crack at that.
All right, great. Dean.
So what Delegate Davis is referring to is the so-called trial penalty that's been observed not just in the Maryland system, but in the federal system and elsewhere around the country. And it's the product of defendants receiving a break for accepting responsibility and pleading guilty. That's sort of the more favorable interpretation of the situation. But it has often been understood, and scholars have criticized the fact that defendants, in effect, are penalized for exercising a constitutional right. So that's a troublesome fact, and it's one that I know the judiciary grapples with. It's a good example of why simply presenting sentencing facts without context would be unwise and misleading, because some defendants go to trial and some don't. And I would fear that the presentation would miss that nuance I do think that this is, Delegate Davis highlights a real issue and problem in the criminal justice system, and one that this proposal wouldn't begin to address.
Delegate Davis, you raise an excellent point, and I would simply add to what the Dean has said, the fact that that issue has actually gone to the Supreme Court of the United States. And the Supreme Court has been very clear, and I think our common sense would say to us, it clearly would be unconstitutional to legitimize a system where a person received a harsher sentence simply because they went to trial. As the Dean says, it would be punishing a person for exercising a constitutional right. So the way the law has resolved that conundrum, if you will, as the Dean mentioned, the view embodied in law, both state and federal, is that what happens is that not that the person is getting a harsher sentence for going to trial, but through mechanisms such as acceptance of responsibility, which is the term of art used in the federal system. When a person pleads guilty to a crime, at least in some sense, that person is taking moral responsibility, perhaps apologizing and perhaps expressing remorse for their behavior. And therefore, the law says that person is entitled to consideration of leniency, whereas a person who goes to trial is not being punished for exercising a constitutional right, but is actually getting the sanction that the law provides for. Now, you can debate how strong that legal construct really is, but that is the theoretical underpinning of the difference. In my own personal view, every case is different, but on the face of it, there shouldn't be any discernible difference in a sentence on the face of it between a person who goes to trial and a person who pleads guilty. But there are other factors, and there almost always are other factors that play into a guilty plea.
Okay. All right, I'm going to go to a question now from Delegate Shoemaker, please. Delegate Shoemaker.
Thank you, Mr. Chairman. I would never deign to try to cross-examine his honor, so I'm going to direct this question to the dean.
A missed opportunity, really, if you think about it. A missed opportunity there, but all right.
Yeah, and it was prompted by something you said, Dean. You indicated that you're apprehensive about legislation that would seek to tie the judiciary's hands by binding them, I guess, to impose sentences within the guidelines because that vitiates discretion and that sort of thing. I believe that's what you indicated. But as I understand the governor's proposal, which I guess was part of the impetus behind this work group, he wasn't proposing to bind judges to compliance within the sentencing guidelines. He just wanted, for purposes of transparency, for it to be disclosed, I guess, for lack of a better word, by members of the bench when they decided to depart from the guidelines and explain the rationale for that. So, I mean, do you think that that's problematic?
So, Delegate Shoemaker, I've seen a version of the proposal that I read to require judges to sentence within the guideline range in certain cases, certain violent crimes and cases arising from plea negotiations. I think there may be different versions of the proposal out there, and you'll see which one is before you this session. I do, as I say, to the extent that anybody thinks that judges should be required as a legal mandate to sentence within a range and would not have the ability to depart upward or downward based on the facts of the case, I would oppose that. As for disclosure, certainly in the federal system, judges are required to express the reasons for their departure from the range. I don't object to that. I am wary of the kind of spreadsheet approach that would purport to describe judicial sentencing practices in the aggregate, but in each case, I would not object to a requirement that judges explain their reasoning for a particular sentence. Judges do that now. I defer to the other three judges who you'll be hearing from, Judge Davis and Judge Morrissey and Judge Avery. They can say more what the practice is, but I believe judges explain their reasoning in all cases and would do so without hesitation.
Thank you, sir.
And in fact, if I can just add very quickly to that last point, in the federal system, what has happened under the now advisory guidelines that the dean mentioned earlier is that there is very serious, and I would even say rigorous review of the reasons for a departure from the guidelines by appellate courts. And that serves very much as a check on the sentencing judge's exercise of discretion. Because in the old days, sentences were totally unreviewable by an appellate court. And judges could be as capricious or unreasonable as they chose. But nowadays, under the advisory guideline system in the federal system, appellate courts do have the jurisdiction to examine the soundness of the reasons. I shouldn't say soundness, the reasonableness of the judge's decision to depart. And it works, I think, very well, very well.
All right.
This, by the way, is another example of the judiciary policing itself in an appropriate, transparent manner that people can be proud of.
All right, are there further questions for this panel? Seeing Deborah Davis, Delegate Deborah Davis for a second bite. Go ahead.
Thank you, Mr. Chair. Judge Davis mentioned something that was really important to me, and that is the judiciary policing itself. I'm a practicing attorney from UB, but and I'm also from Charles County, and we've recently had some issues regarding members of the bench, or a member of the bench in particular. Well, we've had a couple of them. But anyway, I question whether you have enough power or the current system is set up to allow for the judiciary to police itself. I believe in separation of powers. I'm 100% behind that. But do you need, and maybe we can talk about this offline, but what do you need to be more effective and more efficient in policing yourself?
Well, I'm happy to respond very briefly to that observation, and it's a very fair observation, Delegate Davis. My own personal view is that the Maryland courts do a really, I would even say, an excellent job in policing itself. And I think that's true on the federal side as well. And I'm going to tell a very quick story. There was a judge in Montana, a federal district judge with lifetime tenure, who was caught making racist, inappropriate jokes on official court email about President Obama some years ago. And that judge, again, federal judge with lifetime tenure, ended up resigning their commission. I only bring that up to say that judges are human, judges make mistakes, and judges do more than make mistakes, they misbehave, sometimes in their personal capacity, sometimes in their professional capacity. But my perception, having been a Maryland state judge for 25 years, but I think the Maryland Court of Appeals system is adequate for the task of investigating and taking appropriate steps to help judges be better judges and to invite judges who can't live up to the responsibilities to leave the bench. That's just one person's perspective outside the system.
All right. Seeing no further questions for this panel, I want to thank both Your Honor, the Judge Davis and Dean Weish for being with us here today. Appreciate your time and your comments here. And I know I speak for the work group and really appreciating a really thoughtful discussion here this afternoon. So thank you both very, very much.
Thank you.
All right, for our second panel, we're going to hear from the Maryland Judiciary. We're joined by District Court's Chief Judge, who's not a stranger to the Judiciary Committee, Judge John Morrissey, and Judge Shannon Avery from the Baltimore City Circuit Court. They're going to both speak to us after they conclude their remarks. We'll open the floor again to another set of questions and answers from the work group. So with that, Judge Morrissey, Chief Judge Morrissey will go first.
Chairman Clevenger, if it would be acceptable to this work group, could Judge Avery go first and then I would?
Yeah, I think I actually just stepped in it a little bit. I apologize for that. I put district court over circuit court, and being that I practice in circuit court a whole lot, I'm going to be suffering for that for quite some time. So that's fine. I'll take responsibility for that. But let's go ahead. I apologize, Judge Avery. Plus, Judge Avery is from Baltimore City, so I'm in real trouble. All right, so Judge Avery, please go ahead.
All right, Judge Morrissey wants to bat cleanup. I understand. Okay, I'm Shannon Avery. I'm a judge in the Circuit Court for Baltimore City, and I serve as the Vice Chair of the Maryland Sentencing Commission, where I've been since 2014. Prior to my appointment to the bench, I also served on the commission as proxy for Secretary Maynard, who was then the Secretary of the Department of Public Safety and Correctional Services. So I'm a long timer on the commission, and I intend to focus my remarks on the ways in which the transparency legislation affects the commission's work. I also hope to be a resource if you have any questions, so please feel free to interrupt me at any time. The Judicial Transparency Act, at least in its former iterations that I've seen, includes a provision that requires the Sentencing Commission to track and report certain data relating to violent offenses, not the least of which is the identity of each individual judge who imposes sentence. This may seem like an innocuous provision, but it is at cross purposes with the intent and purpose of the sentencing guidelines, and it has the potential to undermine the existence and usefulness of the guidelines. The sentencing guidelines are voluntary in Maryland, and they were never intended to impose a limit on judicial discretion or to gather and or publish judge-specific sentencing information. To the contrary, specific data relating to the sentences imposed by individual judges is irrelevant to the original purpose of the sentencing guidelines, which was and is to reduce disparity and increase fairness across regional, jurisdictional, and racial demographics in Maryland. In other words, a sentence for armed robbery should not be unreasonably different based on the race or color of the offender, or whether the offender is convicted in Washington County or Prince George's County. A little bit of history is helpful in understanding the sentencing guidelines. In an effort to ensure fairness across regional and racial demographics in Maryland, it was the judiciary that introduced the concept of voluntary sentencing guidelines in the late 1970s. After developing and piloting a model to reflect sentencing practices, the Judicial Conference voted favorably and the General Assembly approved the guidelines, adopting them formally in 1983. In 1999, the General Assembly created the Maryland State Commission on Criminal Sentencing Policy, which is a mouthful. We refer to it as the Maryland Sentencing Commission. And that commission's purpose is to oversee sentencing policy and to monitor and maintain the sentencing guidelines. The General Assembly established 6 goals to guide the Commission's work. And I think these goals are as relevant today as they were in 1999 or 1998 when they were debated. Number 1, sentencing should be fair and proportional, and sentencing policies should reduce unwanted disparity. Number 2, sentencing policies should help citizens understand how long a criminal will be confined. Number 3, the preservation of meaningful judicial discretion. Number 4, sentencing guidelines should be voluntary. Number 5, the prioritization of prison usage for violent and career criminals. And number 6, the imposition of the most appropriate criminal penalties. From its inception, the Sentencing Commission was careful to protect judicial discretion by not collecting judge-specific data, but rather collecting data across jurisdictions and topics for purposes of using that data to inform the guidelines. Its purpose was never to issue individual report cards on judges' sentencing decisions, but rather to provide judges with necessary information for imposing sentences that are in proportion to sentences imposed throughout the state in a fair and impartial manner. Judicial discretion in sentencing is deeply rooted and critical to the constitutional requirements of due process and separation of powers. The Judicial Transparency Act, as it's been introduced in the past, contravenes these constitutional values by imposing executive, legislative, and public scrutiny of individual judicial sentencing decisions based solely on the length, or if you want to say the severity of that sentence. The bill does not capture all of the data that is needed to provide an accurate picture of the nuanced and complex sentencing decision, nor, I should say, could it. Judges are required to consider the universe of factors relating to the offense and the offender, including but not limited to the offender's criminogenic needs, amenability to treatment and/or rehabilitation, support in the community, mitigating and aggravating factors, victim safety and statements, gang affiliations, etc. The list is literally endless. And that's what discretion is, right? It's the judge being able to consider all of the factors that are presented to them that relate to the individual case, offender, victim status, all of it. This legislation does not account for those myriad details and factors. The legislation does not account for the prosecutor's recommendation, nor does it account for the vast majority of sentencing events that arise from negotiated plea agreements, where the prosecutor and defense attorney agree to a disposition of a case without trial. These agreements often result in sentences that are lower than the range provided by the guidelines. And the reasons may include the availability or the perceived credibility of witnesses, among so many other factors. In my view, the transparency legislation that has been introduced in the past and has been rejected by the General Assembly repeatedly does not, in fact, promote transparency. The legislation is an effort to circumscribe judicial discretion by focusing on the single factor, the length or severity of incarceration, to the exclusion of all other factors. And the purpose of that is to influence judges toward a rigidity in sentencing by treating the guidelines as having a more mandatory nature rather than the true advisory, voluntary nature that they currently have. So with that, I am going to pause and see if the panel has any questions.
We we were going to hear from both of you if that's okay, but
Oh, sure.
that's fine. Let's go to Chief Judge Morrissey now.
Good afternoon, Chairman Clippinger and members of the work group. It is an honor to be on the same panel as Judge Davis and my own Dean Weiss. And Delegate Davis, I was going to mention that you are another UB graduate. I know that from the many years that we've known each other. So we're well represented on this panel and in this work group, and I'm proud of my time at University of Baltimore. And Judge Avery too, my colleague from Judge Avery. Judge Avery and I, prior to becoming the Chief Judge, I also served on the Sentencing Commission as the District Court member for 8 years. And during that time, Judge Avery was the Department of Public Safety, is that correct? The representative, and would regularly attend those meetings. It was a great experience for a young judge to serve on that commission, and I learned lots and lots of information, and still pay very close attention to Dr. Saleh and the work of that committee. And I attend most of the meetings and watch by video now with a lot of the meetings that go on. I'd like to just take an opportunity to tell of 2 cases that I've handled over the course of my 16-year career. And one involved a woman named Miss Lemon. I believe that was her name. This was a long time ago. And she was a stalwart member of her community. She was in her, I want to put this delicately, in her senior years. I believe she was in her late 60s or even perhaps in her early 70s. And she was a church lady who regularly sang in the choir. And in fact, on the day of her sentencing, there were any number of individuals from her church there in the courtroom. She had no prior criminal record whatsoever, had never been involved with the law prior in her life. And so she came home one day, and much to her disappointment and surprise, she found her husband with another woman in the house, a paramour. And for reasons that came out in the sentencing, she picked up a 2x4 that happened to have nails in it, and started swinging it wildly at both of the individuals and struck both of the individuals with those. And there was a pause there when I said she picked up a 2x4, and it was very curious to me as why I think everyone would ask, what was a 2x4 doing laying around the house, right? Was there premeditation? And these are some of the things that judges go through, right? Was she walking around with it too? Did she go out and form an intent to come back in and harm these people? Well, it turned out that they were doing construction on their house, and this was the closest thing that she could grab. It became readily apparent, well, she was charged with, I can't remember whether she was charged with attempted second degree murder. I know she was at least charged with first degree assault, but as happens sometimes in the district court, that a first degree assault would normally be indicted or taken up to the circuit court and would be tried in the circuit court. But many times, for whatever reasons, the first degree assault goes and we're left with a second degree assault that very much is a first degree assault, but it's now been written down to a second degree assault. And so that would be tried in front of a judge in front of the district court, which at the time I was in Prince George's County. It became readily apparent to me, in working through the different various things that I think about in trying to prescribe a sentence, that although she had injured someone, and these people had injuries, not significant injuries, but injuries enough to send them to the hospital, that I had kind of almost immediately ruled out that I would incarcerate this individual. I didn't see any purpose in any way, in any retribution or in any type of rehabilitation, that this would change this woman in any manner by sentencing her to jail. So she pleaded guilty. She was remorseful during the sentence. She kept repeating, I never should have picked up that stick. That's why I remember this case. I never should have picked up that stick. I never should have picked up that stick. And we talked through it, and I took an extended period of time, and I sentenced her to probation, and there were lots of conditions that went with that probation. A second case that I wanted to send out as an example was on a bail review hearing. And I know this isn't a sentencing, but it is a time where judges have a lot of discretion in order to either detain the individual or to release the individual prior to trial. And this individual was charged with a sole count of trespass, which only carries a 90-day potential jail term. but he was charged with trespass because he was setting a ladder up to the second-story terrace apartment that his ex-girlfriend that he had broken, or they had broken up 6 months before. He was setting that ladder to get into that apartment. Now, he was arrested when he was setting up the ladder, so I don't think the prosecutor or the police could charge him with anything other than trespass, and that's the way the case came to me. But the victim was there in the courtroom, and she was terrified. I mean, absolutely terrified, and the hair stood up on the back of my neck. And I held that individual no bond with no prior criminal record whatsoever at all. Those are difficult decisions, as you can imagine. I don't take either of those very lightly. And I loved what Judge Davis said about all judges want to be excellent. I think I know I do, and I know most of my colleagues do also. The problem with those two cases is that if you look at them on paper, you might scratch your head as to why I would do that. Why would I, if it came out that I sentenced this person to probation on a potential 10-year jail term for an assault in the second degree, why would I have done that? And that won't reflect in bulk data. It won't be shown in the type of stats that I think that the bill was envisioning, or that these what is being termed as transparency, an attempt to be more transparent for the judiciary. And it would have been the reverse for the trespass charge, where I would have held a person no bond with no prior criminal record on a minor, what I consider a minor violation of the law. But I think my call was right on both of those. It just wouldn't be reflected in the paper, in a spreadsheet that had data in front of you. I just like to touch base too, in all the cases are like that. Each case has an individual aspect to it. And I think we've all mentioned that, all the presenters have mentioned that. And I invite everyone, and we've done this before, to come in and watch sentencings and see the nuance that goes on. And there's a dynamic in the courtroom that occurs a lot of times, and it depends on who's in the courtroom and who's not in the courtroom. And all those factors go into whatever it is that we're going to decide to make that sentencing decision. There are a number of other ways that a lot of, because some of the questions that have been presented and some of the other things that have been touched on as to transparency in the judiciary, and some of the metrics that we do already use. And as Judge Davis mentioned, one of theirs was metrics as to our efficiency. And we do publish our time standards data every year. We have time standards data as to each of the case types that we have, whether it be a civil case or a criminal case. We try to hold ourselves to a standard of X number of days. For minor traffic, it's 120 days, and we measure ourselves against whether we're meeting that or not. We also have an office inside the administrative office of the courts that is, we don't call it an ombudsman, but you can think of it as that. It's run out of the Access to Justice Department of the AOC, and they field complaints. The governor apparently has a website where some people complain to him, and then one of his staff calls out ones that are related to the judiciary and passes them to us. But they can also approach us directly, anonymously if they want, or with their names. And this office is designed to try to address those concerns, to get them the resources that they have, to point them in the right direction. And they created a report for leadership of each of these complaints and what action they've taken that day. I think we also mentioned the Commission on Judicial Disabilities. I do believe they are very robust. I think if you ask any judge, they would agree that they are a very robust organization. I think some of the judges would think they're overly aggressive at times if you ask them. But I think they do a very, very good job in any of the complaints. They will, if anyone wants to complain about the behavior of a judge, they can file that with the commission. The commission has investigators, and they will open a case and take a look at it and move forward. And then finally, both my administrative judges and myself as the administrative head of 124 judges and almost 2,000 employees, kind of am the recipient of a lot of mail that comes my way. Sometimes good, but in the majority, not so good. of various complaints. Some are of the ilk of sovereign citizens that I can't quite understand, but others raise very salient points about the judge or demeanor, the demeanor or the behavior of a judge in trial or in court or in hearing or whatever they were at. And I review every one of those letters. And if necessary, I will pull the file and the recording and review those. And if it requires additional action after that, I will speak to my administrative judge. My administrative judge gets the same kind of letters too, and they do the same thing that I do. Sometimes we're copied jointly, but sometimes they get the letter first. Sometimes I get the letter first, but we'll meet jointly and we'll discuss what, if any, action we need to take. If we do need to take action, we'll take that judge in and have a meeting with that judge. And then finally, there again, Judge Davis mentioned a mentorship program, and I believe it was 4 or 5 years ago. We initiated a mentorship program for all of our new judges with a more senior judge. Some of the judge, and they've all been trained to be mentors. It's a volunteer situation on behalf of the more senior judges. And by all accounts, it's been an excellent program that's really provided a lot of support to our new judges so they get off on the right foot. So with that, I will I'll certainly end with just the idea that again, Judge Davis, you took a lot of what I was going to say. That's what the problem with going forth is that we're not, the judiciary is not supposed to be tough on crime. That's not my job to be tough on crime. It's not my job to be easy on crime. My job is to be fair and neutral and impartial. And, we all took an oath to do that. And I can speak for 123 other judges that I believe that we all strive for that every day. And I'd be happy to answer any questions, Chairman.
All right, thank you very much. Thank you to both of you for your thoughts and your comments. Are there questions from the work group? Wow, nobody has any questions for the work group. For the first time in the history of the Judiciary Committee, we're letting 2 judges get off the stand without asking any questions, really. Right, I'll ask a couple and then we'll go from there and see what happens next. I'm not sure who I'm directing this towards. I guess the broader question, and I think you both touched on this in your remarks, the broader question is, we want at least as I have read the governor's bill, it does 2 things. It does seek first to say that sentences for certain cases for crimes of violence need to be, the active sentence needs to be within the sentencing guidelines. And then the second part would release data regarding sentences handed down in crimes of violence. So predominantly it would be in circuit court cases. It appears it would be more in circuit court cases than in district court cases, but I think there'd be some exceptions to that. I guess my broader question is there a way to go forward with that could provide the nuance, that could provide the nuance to people who are looking at it? Or is that, I'm just going to leave it there. Is there a way to provide that nuance so that you're able to compare an apple, an orange, and a grape in the different cases that they see?
So I would answer that question this way, Chairman. I would say if you wanted to issue a report card on parenting, what data points would you look at? Would you look at the academic success of the children, the health, the physical health of the children, the happiness of the children? I think that it just depends on what perspective you're bringing to this question, what factors you're going to look at. The important thing is that judges are constitutionally designed to be insulated from popular criticism. That was Alexander Hamilton's intent. That was the intent of the framers of our system of government, that the individualized decisions that are made by judges, that the judges and we as judges are bound ethically not to be influenced by public clamor or public opinion. So, I mean, I guess if you want to judge judges, you have to judge them, as Judge Davis said, on the effectiveness of the work we do, the attention that we give to each individual case, the discretion that we exercise, which means that we consider all of the factors, that we don't consider improper factors, right? For example, an improper factor would be for a judge to consider the fact that a defendant rejected a plea offer. And we've seen that. And, you know, we may have heard of cases where judges, you know, there's a perception that a judge has punished a defendant for going to trial. Personally, I'm going to tell you, and this is, again, I mean, I'm in Baltimore City. I have my community of judges. I don't believe that there is a trial penalty. I don't think that I or my colleagues have that viewpoint at all. I do understand that there are plea offers that are made that are based on the prosecutor's perception that their case may be weak in some way. You know, you might have a weak case because you have a victim who is terrified to testify. And so as a prosecutor, you might offer a very low sentence as a negotiated plea agreement because you're afraid to put this witness on the stand, or any other reasons. I mean, the reasons are endless. I'm just putting examples out there. The judge ought not be involved in that negotiation. The Court of Appeals has told us, and we know that it is not a good practice for the judge to roll up their sleeves and get involved in that negotiation. Why? Because that sentence is not our sentence. That sentence is not based on hearing the facts of the case and making a nuanced ruling based on the myriad factors about the offense, the offender, etc. We ought to stay out of it. I'm sorry about the noise. I'm on Calvert Street here. Apologize. My point is that the sentencing that happens by a judge after a trial is a different event. But if there is any perception whatsoever that I am including in my sentencing consideration the fact that a defendant rejected a plea offer, that is appealable. It should be appealable, and I should be reversed. And I will be reversed because that is an improper consideration. Another improper consideration that I would be reversed for, I haven't been, but I could be reversed for, is something to the effect of, this is a violent crime. Someone was hurt. I always impose the maximum sentence. Or I would never impose less than 15 years. Anytime you say words like that, or you imply words like that with any other actions that you take in the case, you will and you should be reversed. So a lot of the concerns I think that people have that are very important, genuine concerns about the sentencing process are baked into the due process of what we do. And I love to talk about that. I will talk to you about that all day because I was an appellate lawyer for 15 years and I've argued these cases half the time from the public defender side and then the other half of the time when I was in the AG's office. So, I mean, this is what I love about the law, is that there is a remedy for a lot of these problems. But I will direct my comment directly to Delegate Davis, because although there is technically, theoretically, a remedy for that problem, I understand, and I am not disputing that you may see something different on the ground in your practical work that you do. And I think that that's a conversation we should be having. I don't want you to feel like I'm putting you off in any way whatsoever. I just think that the legislation that has been proposed is not really going to get at that. I think it creates problems that are even today unforeseen down the line as it relates to due process.
All right. Are there questions from the work group for the second panel? All right, seeing none, I tried. We want to thank you both very much. Thank you both very much for your thoughtful comments and for being here with us today. That's going to conclude this meeting of the work group. The House Work Group on Judicial Transparency will meet a third time in the next couple weeks. We're working on details and panelists at this point, and we will post that date to our work group page on the Maryland General Assembly's website, and we will notify work group members. Again, thank you all very much for being here today. Thank you for your time, and thanks everyone for your participation. We really do appreciate it. And happy opening day. Thank you all very much.
Thank you all very much.
Thank you. We even got the dog's approval, right?
That's true.
Chairman Clippinger, I'm trying to take out